My farm gate meant nothing to her. Every Tuesday, her Escalade tore through my fence line. I complained. My face. Then she brought fake paperwork, claiming my land was hers. My son got blamed for a crime he never committed. One night, she let my horses loose on the highway. Then I found the real story behind her easement. What happened next made the whole town turn against Linda Kowalski. My name is Mark Ellison, and I've lived on this land since I was 6 years old, back when my father still baled hay by hand and the nearest neighbor was 2 miles down a gravel road. Now that gravel road is called Meadowbrook Lane, paved and lined with cookie-cutter houses, and my 40 acres sit like a stubborn island in the middle of a subdivision that grew up around me while I wasn't looking. My wife Rachel keeps the books for our small horseboarding business. And our kids, Tyler and Emma, grew up mucking stalls before they learned to ride bikes. We weren't rich, but we were steady, and steady was enough, until the HOA got a new president who decided our fence line was just an inconvenience standing between her and a shortcut. The subdivision's HOA had existed for a decade before Linda Kowalski ever set foot in Meadowbrook Ridge, and for most of that decade it barely bothered us. Dues got paid, someone mowed the common areas, and nobody cared what color you painted your mailbox. That changed the year Frank Kowalski, Linda's husband, took over as treasurer and started tightening every rule in the bylaws like a man preparing for a war nobody else knew was coming. When Frank passed unexpectedly 2 winters ago, everyone assumed the HOA would go back to being background noise. Instead, Linda ran unopposed for president at the next meeting, standing up in her funeral black to remind the room that someone has to carry on Frank's vision for this community. Nobody clapped. That silence, I'd learn, was exactly the room she needed. I'd met Linda maybe 3 times before that meeting, always at a distance, a wave across the mailbox cluster, a nod at the 4th of July potluck. She struck me as sharp-eyed and overly interested in other people's property lines, the kind of neighbor who measured your grass height from her car window without ever slowing down. The first real friction came over the access road, a gravel cut-through along my northern fence that predates the subdivision by 50 years. My father used it to move hay equipment between fields. The developers who built Meadowbrook Ridge used it too. Briefly, with my father's permission, back when they were still trenching utility lines. That permission was verbal, a handshake between my father and the original developer, never once written down because nobody imagined the road would matter after construction ended. My father figured that was the end of it. He was wrong, though none of us knew it yet because somewhere in a filing cabinet, that handshake was about to be rewritten as something else entirely. Linda's first order of business as president was commissioning a community resource survey, supposedly to catalog shared amenities like the pool and the mail kiosk. Buried in that survey, almost as an afterthought, was a line item calling my northern access road a shared community easement. Per historical agreement, nobody in the room questioned it. I wasn't even at that meeting. I only found out about the survey language when Diane, one of the few board members with a conscience, mentioned it to Rachel at the grocery store, half apologetic, half confused. I don't remember voting on that, Diane admitted. Rachel relayed it to me that night, and I laughed it off, figuring it was some clerical mix-up that would sort itself out. It didn't sort itself out. Within a month, Cars started using the gravel cut-through as a shortcut to bypass the single stoplight on the main road, shaving 4 minutes off the morning commute. My gate, which had stood closed my entire life, was suddenly being treated like a public thoroughfare by people who'd never once asked my permission. I put up a simple chain across the gate posts. Nothing dramatic, just a clear signal that the road wasn't open to traffic. Within 2 days, someone had cut the chain and left it coiled neatly on the ground beside the gate post, almost like a taunt, like whoever did it wanted me to know exactly how little my ownership meant to them. I called the sheriff's non-emergency line to report the vandalism. The deputy who came out, a heavy-set young man named Roy, took my statement without much interest, glancing at his phone more than at my fence. He left without filing anything I could ever find a record of later, which struck me as odd, though at the time I chalked it up to small-town laziness. I didn't yet know that Deputy Roy Kowalski was Linda's second cousin, a fact nobody bothered to mention and one that would matter a great deal more before this was over. Small towns keep their family trees quiet until you need to untangle one, and by then it's usually too late to matter. I replaced the chain with a heavier padlocked gate, welded the hinges myself, and figured that would settle it. Rachel wasn't so sure. She'd started noticing Linda's Escalade idling at the end of our driveway some mornings, engine running, Linda just sitting there behind sunglasses like she was studying the property, cataloging something only she could see. At the next HOA meeting, I showed up uninvited to ask, politely, why my land had been labeled a community easement in a survey I'd never seen. Linda smiled at me from behind the folding table like I'd asked her something adorable. The developers granted us that access decades ago, she said. It's all documented. I can show you the paperwork sometime. She never showed me the paperwork that night, or the next week, or the week after. Every time I asked, there was a reason. The file was at the county office. Her assistant was on vacation. The copier was broken. I started to understand that the paperwork wasn't a document so much as an idea Linda intended to make real through sheer repetition. By the end of that first month, I'd stopped assuming this was a misunderstanding. Something about the way Linda smiled, unbothered, whenever I brought up my own fence line, told me this wasn't going to resolve itself with a friendly conversation. I didn't know yet how far she was willing to go, but I was about to find out. The first time Linda's Escalade actually drove through my new gate, I wasn't even home. Rachel called me at the feed store, her voice tight, describing how Linda had simply nosed the SUV against the padlocked gate, revved the engine, and shoved it clean off its welded hinges like it was a garden ornament instead of an actual barrier. By the time I got back, the gate lay twisted in the grass, and tire tracks cut a fresh scar through the field where my yearlings graze. Linda was long gone, but a neighbor across the road had seen the whole thing and said Linda hadn't even slowed down afterward, just drove on through toward the subdivision like nothing had happened. I filed a police report that afternoon, this time insisting on a case number, a name, something official I could hold on to. The officer who responded wasn't Roy this time, a woman named Officer Castillo, and she seemed genuinely troubled by the tire tracks and the mangled gate. This is property damage, she told me. You should press this. When I confronted Linda directly, catching her outside the community mailbox kiosk, she didn't deny driving through the gate. She simply reframed it. That's a shared easement, Mark. You're the one who put an illegal barrier across community property. If anything, you owe the HOA for the inconvenience you've caused everyone this month. I asked her, calmly, to produce the document proving that claim. She told me it was being reviewed by legal and that I'd have it soon. I'd hear that phrase, being reviewed by legal, more times over the following months than I could count, always dangled just out of reach, always somehow never quite ready to be shown. Rachel wanted to hire a lawyer immediately, but our savings were tied up in a new hay barn we'd broken ground on that spring, and lawyers weren't cheap. I decided instead to visit the county recorder's office myself, hoping to find the original plat map and settle the easement question with cold, simple paperwork nobody could argue with. The clerk at the recorder's office, a patient older man named Walt, pulled the original 1974 plat for me without hesitation. It showed my father's property boundary running clean and unbroken along the northern line. No easement, no shared access, nothing granting anyone but our family the right to use that gravel road. I felt, for the first time in weeks, like solid ground. I made 3 copies of that plat map before I left. One for Rachel, one for my own files, and one I intended to bring straight to the next HOA meeting. Walt mentioned, almost as an afterthought, that someone else had requested the same document just 2 weeks earlier. A woman, he thought, though he couldn't recall the name for certain. At the next HOA meeting, I laid the plat map on the folding table in front of the whole board. Linda barely glanced at it. That's the original filing, she said smoothly. The easement was granted afterward, in a private agreement between the developer and your father. I have a copy at home. I'll bring it next time. Diane, the board member with a conscience, asked to see this private agreement too, and for a moment I thought the room might actually hold Linda accountable. But Linda pivoted instantly, accusing me of harassing the board with legal threats and suggesting my chain link fence itself violated the community's aesthetic guidelines. The meeting dissolved into arguing about fence height instead. Within a week, I received my first official HOA violation notice, not about the gate, but about an unrelated fence section near our barn that had apparently been non-compliant for years without a single complaint. The timing wasn't subtle. Linda was learning, fast, that if she couldn't win the real fight, she could bury me in smaller ones. Then came a second notice, this one about our farm stand sign at the end of the driveway, cited as an unauthorized commercial structure despite having stood there, unremarked upon, for 11 years. Each notice carried a fine, small individually, but stacking fast, and each one required a written appeal that 8 hours out of already exhausting weeks. Rachel started keeping a folder just for the notices, color-coded and dated, because we both sensed we might need the paper trail someday. She's building a case against us, Rachel said one night, staring at the folder. Not for the gate. She wants enough violations on file that if this goes to court, we look like the problem. I brought up Linda's pattern of retaliatory notices at the next board meeting, and for the first time, Harold, the HOA treasurer, spoke up in my defense, noting that our property had never been cited before Linda's presidency began. Linda thanked him for his input, in a tone that made it clear his input wouldn't be welcome again. That night, someone spray-painted a crude message across our new farm stand sign. Nothing overtly threatening, Just enough vandalism to feel like a message. I couldn't prove who did it, and the sheriff's department, understaffed and unbothered, treated it as routine teenage mischief rather than anything connected to the gate dispute simmering just up the road. Tyler, my 16-year-old, started talking about installing a trail camera near the gate, half joking that we should catch Linda in the act like some kind of nature documentary. Rachel and I brushed it off at first, more concerned about school and chores than surveillance equipment, though the idea would come back to matter far more than any of us guessed. The gravel road itself became a kind of front line. Neighbors who used to wave now avoided eye contact, uncertain which side of the fence dispute they were supposed to stand on. A few, quietly, told Rachel they believed us about the plat map, but none of them wanted to say so out loud at a meeting where Linda might hear. By the time the second month ended, I understood something Rachel had already sensed. This wasn't really about a shortcut through a field anymore. Linda wasn't fighting for 4 minutes off her commute. She was fighting because losing, even a small fight over a gravel road, wasn't something her version of herself could survive in front of the neighborhood she'd appointed herself to rule. 2 weeks later, a certified letter arrived at our mailbox, HOA letterhead stamped across the top, informing us that the Meadowbrook Ridge Homeowners Association was pursuing a formal claim to a prescriptive easement across our northern access road, citing decades of continuous community use. I read it twice before I understood Linda had stopped asking and started litigating. Rachel called our insurance agent first, who recommended a local attorney named Carla Alvarez, a woman who'd handled property disputes for 20 years and had, coincidentally, gone up against the previous HOA board once before over a drainage easement. Carla took one look at our plat map and told us plainly that a verbal handshake from decades ago wasn't a prescriptive easement. Prescriptive easement claims require open, continuous, and adverse use for a statutory period, usually without the owner's permission, Carla explained, tapping the map. If your father allowed the developers to use that road, that's permissive use. Permissive use doesn't create an easement, no matter how long it goes on. She knows that, or her lawyer does. Carla's mention of her lawyer was the first I'd heard that Linda had actually retained one. It turned out the letter had been drafted not by some faceless HOA counsel, but by a small firm 2 towns over, Pearson and Associates, a name that meant nothing to me yet, though it would come to mean a great deal before this was finished. Hiring Carla meant real money leaving our accounts every month. Money that should have gone toward the barn roof or Tyler's truck fund. Rachel and I argued quietly about it more than once. Not because either of us doubted the fight was worth having, but because neither of us had budgeted for a war that seemed to have no ceiling. Carla suggested we request mediation before things escalated into a full lawsuit, partly to save money, partly because judges generally like to see both sides attempt to talk before filing paperwork. Linda agreed to mediation almost too eagerly, which should have told me something about how confident she felt walking into that room. The mediation session took place in a beige conference room at the county building. Linda arriving 10 minutes late in a blazer she clearly didn't wear to garden club, flanked by a young man in a sharp suit who introduced himself only as counsel. He didn't shake my hand. He barely looked at me at all. For nearly 2 hours. Linda painted herself as a reasonable community leader simply trying to preserve decades of neighborly cooperation that I, apparently, was threatening to destroy over a fence. She never once raised her voice. She never once looked flustered. I realized watching her, a performance she'd clearly rehearsed long before walking through that door. When the mediator asked directly for the written agreement Linda claimed existed between the original developer and my father, her lawyer produced a single typed page and signed, undated, referencing an understanding reached in good faith. Carla read it once and slid it back across the table. "This isn't a legal document," she said. "This is a memo somebody wrote." Mediation ended without resolution, both sides restating their positions, the mediator recommending we continue discussions. Linda left first, pausing at the door just long enough to tell me, quietly, that she hated that it had come to this. In a tone so gentle it took me a full minute afterward to realize I'd just been threatened. Within days, rumors started circulating through the neighborhood Facebook group, always vague enough to avoid naming me directly but specific enough that everyone knew exactly who they meant.
Posts about certain residents blocking emergency access. About farm smells.
I wasn't in that Facebook group. Hadn't bothered joining since I found most of the posts insufferable. But Rachel was, and she watched the comments pile up with a kind of sick fascination. A few neighbors pushed back, gently, asking for evidence. Most simply liked the posts, or said nothing at all, which felt like its own kind of verdict. Emma came home from school one day upset because a classmate's mother had told her daughter not to play at the Ellison place anymore. Emma didn't understand why. I didn't have a good answer for her either. Beyond the obvious, ugly truth that adults sometimes weaponize their children's friendships to punish people they've decided are enemies. Our farm stand, which had quietly supplemented our income with fresh eggs and seasonal produce for over a decade, started seeing regulars cancel their standing orders. One woman, apologetic on the phone, admitted Linda had personally suggested at book club that buying from us was supporting an ongoing legal dispute against the community. Tyler, embarrassed and furious in the particular way only a 16-year-old can be, wanted to post something online defending the family. Rachel talked him out of it, worried that anything we said publicly would only feed Linda's narrative that we were the aggressive, difficult family stirring up conflict in an otherwise peaceful subdivision. I started keeping my own folder to match Rachel's, documenting every incident with dates, times, and photographs, the gate, the fines, the tire tracks, the spray paint, the canceled farm stand orders. Carla had told me early on that in a fight like this, the person with better records usually wins. Eventually, even if it takes longer than feels fair. Harold, the treasurer who'd spoken up once in my defense, quietly reached out to Rachel at the grocery store again, this time looking over his shoulder before speaking. He said the board had approved unusual legal expenses over the past few months, more than he could account for, all routed through Pearson and Associates without much explanation from Linda. Diane, too, started pulling away from Linda's inner circle, though carefully, still worried about her own standing in a neighborhood where crossing Linda seemed to carry consequences nobody wanted to name outright. She mentioned to Rachel, in passing, that Linda had once told the board, the Ellisons will fold once the fines add up enough. That phrase stuck with me for days afterward, once the fines add up enough, because it confirmed what I'd suspected since the first bogus violation notice. This had never been about an easement or a shortcut. Linda intended to bankrupt us into submission through paperwork. Fine by fine, appeal by appeal, until giving up seemed easier than fighting. Carla filed a formal response disputing the prescriptive easement claim and requesting Linda's firm produce any actual recorded documentation supporting it. Weeks passed with no reply beyond a form letter acknowledging receipt. In the meantime, 3 more violation notices arrived at our mailbox, each one pettier than the last, each one carrying its own separate fine. One notice cited our mailbox post for being non-uniform in a subdivision where, ironically, no 2 mailboxes matched anyway. Another cited a birdhouse Emma had built for a school project as an unauthorized structure. I laughed when I read that one, a short, humorless laugh, because the absurdity was starting to feel less funny and more exhausting. Rachel suggested we start attending every single HOA meeting. Not to argue, just to be present. To make it harder for Linda to make decisions about our property without at least having to look at our faces across the room. It became a routine Tuesday nights. Folding chairs. Linda's calm smile aimed directly at us like a spotlight. At one such meeting, a new resident, unaware of the history, asked innocently why the gravel road behind the Ellison farm wasn't paved for community use. Linda answered before I could, describing it as still under legal review, which was, to come to learn, her preferred way of describing anything that hadn't yet gone her way. I finally confronted her after that meeting, in the parking lot, asking directly why she wanted that road so badly when a 4-minute detour barely mattered to anyone's daily commute. For the first time, her composure slipped, just slightly. "You have no idea what that road is worth," she said, then caught herself and walked to her car. That comment nagged at me for days. Carla, when I mentioned it, raised an eyebrow and said something similar had occurred to her too, that fighting this hard over a shortcut made little sense unless the road itself, or something connected to it, held value neither of us yet understood. Carla requested county records on any development plans, easements, or utility filings connected to the gravel road and the land immediately surrounding it. It took another 2 weeks for the records to come back. But when they did, they revealed something neither of us had expected. A decade-old, unfinished application for a secondary subdivision entrance. Never completed, never approved. The application, filed years earlier under the original developer's name, proposed extending the gravel road into a full paved entrance connecting Meadowbrook Ridge directly to the state highway, cutting straight through what was now my northern pasture. It had stalled for lack of funding and, apparently, been forgotten by everyone except, seemed, Linda. If that second entrance were ever built, property values along that stretch would climb sharply, particularly for homes closest to the new access point, homes that Carla discovered after another day of digging. Linda herself owned 2 of, purchased quietly under an LLC registered to her maiden name 3 years earlier. I sat with that discovery for a long time before saying anything to Rachel. This had never been about convenience, or community spirit, or even spite. Linda wanted that road built, wanted my land beneath it, and had been laying the legal groundwork to take it from me piece by piece long before I ever noticed the fight had started. Carla cautioned me not to move too fast with what we'd found. An LLC purchase wasn't illegal by itself, and proving intent would require more than a hunch and a stalled application from years ago. "Keep building the record," she told me. "When we go to court, we want this undeniable, not just suspicious." Not long after, A cease and desist letter arrived from Pearson and Associates, demanding I remove my gate entirely, citing obstruction of a documented community access point, and threatening a lawsuit for damages related to commute disruption suffered by residents. The letter was signed by a name I recognized instantly once Carla pointed it out: Chad Pearson. Chad Pearson, turned out, was Linda's son-in-law, married to her daughter for the past 4 years, running his small firm out of a strip mall office 2 towns over. Carla had crossed paths with him once before, describing him as aggressive, not particularly careful, and always looking for a case that could make his name. Knowing Chad's connection to Linda didn't change the legal facts, but it changed how I read every letter that followed, no longer the voice of an impartial legal process, but a family enterprise, mother-in-law and son-in-law working in tandem, one filing threats while the other collected fines and quietly bought up land. Harold, still feeding Rachel small pieces of information from inside the board, mentioned that Linda had pushed hard for the board to approve additional legal retainer funds for the easement matter, despite Diane's objections that the community had never actually voted to fund a lawsuit against a single homeowner using shared dues. The board meeting where that vote came up turned into the ugliest one yet. Diane openly questioning why HOA funds were being spent fighting a neighbor instead of fixing the community pool pump that had been broken for a month. Linda accused Diane of not understanding governance and moved to table the discussion instead of answering. I started noticing, too, that the HOA's official Facebook page had begun quietly deleting comments that questioned the legal spending, while amplifying posts painting me as uncooperative. Rachel, still lurking in the group, took screenshots of everything before it disappeared, adding them to the growing folder that Carla kept referring to as our timeline. One night, our dog Biscuit started barking furiously near the northern fence line around midnight, waking the whole house. I walked out with a flashlight and found nothing obviously wrong, though the padlock on the rebuilt gate had been tampered with, scratched around the keyhole like someone had tried, unsuccessfully, to pick it. I installed motion sensor lights along that stretch of fence the next weekend, more out of frustration than any real expectation they'd solve anything. Tyler helped me run the wiring, still talking about his trail camera idea, and this time I didn't brush it off. Fine, I told him. Let's set one up. The camera Tyler mounted was cheap, battery-powered, aimed at the gate from a fence post 30 yards away, disguised inside a plastic birdhouse he'd built for the occasion. Neither of us expected much from it. It felt more like a symbolic gesture than a real plan, a small act of control in a situation that otherwise felt entirely out of our hands. 3 nights later, the camera caught its first useful footage. Not Linda, but a young man in a hooded sweatshirt cutting through the fence wire near the same spot Biscuit had barked at weeks earlier, working quickly and deliberately before disappearing into the dark toward the subdivision instead of away from it. I couldn't identify him clearly from the grainy footage, and Carla warned me not to jump to conclusions about who'd sent him, even though we both suspected the timing was no coincidence. What mattered, she said, was that we now had proof someone was actively sabotaging our property, not just filing paperwork against it. I filed the footage with the sheriff's department, insisting this time on a supervisor rather than Deputy Roy, and for once, someone seemed to actually take it seriously, promising to review the footage and check it against known local troublemakers. It was the first small victory I'd felt in months, and I let myself believe, briefly, that things might finally be turning. For almost 3 weeks after the sheriff's supervisor got involved, an unusual quiet settled over Meadowbrook Ridge. No new violation notices arrived. The Facebook posts about certain residents dried up. Even Linda, on the rare occasions I saw her at the mailbox kiosk, offered a stiff, distant nod instead of her usual practiced smile. Carla told me the timing made sense, with a sheriff's supervisor now aware of vandalism on our property. Linda's lawyer had likely advised her to pull back publicly while whatever legal maneuvering continued quietly behind the scenes. "This isn't over," Carla warned. "It's just gone underground for a while. Use the quiet." I took her advice literally, spending that stretch of calm reinforcing what we already had rather than waiting for the next attack. We planted a dense row of arborvitae along the inside of the fence line, both for privacy and, honestly, as a small psychological wall between our land and whatever Linda still had planned. Rachel used the lull to quietly reach back out to a few of the neighbors who'd once been friendly before the rumors started, inviting them over for coffee, letting them see for themselves that nothing about our family matched the picture painted in those vague Facebook posts. A few came, awkwardly, for believing the worst. Diane started stopping by more openly now, no longer worried about being seen talking to us, sharing more of what happened inside board meetings we didn't attend. She mentioned that Linda had grown noticeably quieter in recent sessions, deflecting questions about legal spending instead of steamrolling over them the way she once had. Harold, emboldened, finally requested a full accounting of the HOA's legal expenditures at one meeting, a request Linda tabled twice before agreeing, reluctantly, to provide a summary next quarter. Diane told us afterward that the summary, when it eventually appeared, was vague to the point of meaninglessness, listing amounts without any real itemization behind them. Emma's classmate's mother, the one who'd discouraged playdates at our place, actually approached Rachel at pickup one afternoon to say she felt foolish for repeating gossip she'd never bothered to verify. It wasn't a full apology, but it was something, and Emma started getting invited over to friends' houses again for the first time in months. Tyler kept his trail camera running out of habit more than necessity during the stretch, and most nights it captured nothing but raccoons, a curious deer, and once, memorably, Biscuit chasing his own reflection in the camera's night vision glow. We almost laughed about disabling it, joking that the drama, for now, had genuinely gone quiet. I used part of the lull to finally start pouring concrete footings for a real wall. Not the flimsy chain-link fence that had been torn down twice already,
but a proper stone-faced barrier running the length of our northern property line. Something built to outlast arguments, lawsuits, and any escalade that ever tried it again.
Rachel worried, quietly, that building something so permanent might read as provocation. Another log thrown onto a fire we were hoping had finally died down. I told her I didn't care how it looked anymore. After everything, the gate, the fines, the sabotage, I wanted something solid between my family and whatever Linda decided to try next. We hired a local mason, an older man named Sam who'd built half the stone walls in 3 counties, and he worked steadily through that quiet stretch, laying block after block along the fence line while the arborvitae behind it slowly filled in the gaps. For the first time in months, I slept through the night without checking the motion lights. Even the HOA meetings during this period felt almost normal again. Discussions returning to pool maintenance schedules and holiday decoration guidelines instead of easements and legal retainers. Linda ran the meetings with her usual composure, but something in her posture had changed. A stillness that looked less like confidence now and more, I thought, like calculation. Carla warned me repeatedly not to mistake this stillness for surrender. People like this don't stop because they've had a change of heart, she said during one of our check-ins. They stop because they're regrouping. Watch for something bigger coming, not smaller. I nodded along, though part of me wanted, badly, to believe the fight was finally over. The wall reached shoulder height by the end of that third week. A visible, physical answer to 18 months of gates and chains and paperwork. And for the first time since Linda took over the HOA presidency, I felt something like ground beneath my feet again. I'd realized soon enough. The calm just before everything got far worse. On a Sunday evening near the end of that quiet stretch, Rachel spotted Linda's Escalade parked at the far end of the gravel road. Engine off. Linda simply sitting inside, staring toward our half-finished wall for nearly 20 minutes before finally driving away. Neither of us said much about it that night, but we both understood the silence had ended. 2 weeks after Rachel saw Linda parked staring at our unfinished wall, Carla received formal notice that the HOA, through Chad Pearson's firm, was now filing a full civil suit, not just reasserting the prescriptive easement claim, but demanding an emergency injunction to halt construction on what the filing called an unauthorized barrier obstructing community access. The lawsuit named both the wall and the earlier gate as violations, seeking not only removal but monetary damages for loss of convenient access suffered by residents over the preceding 18 months. Carla read through the filing twice before shaking her head. "This is thin," she said. "But thin doesn't mean cheap to fight. We were looking," Carla estimated, "at several $1,000s just to respond properly, with no guarantee the fight would end there." Rachel and I sat at the kitchen table that night doing math we didn't want to do, weighing what the barn roof repair would have to wait for against what continuing this fight would cost us. Sam the mason, hearing about the lawsuit, offered to keep working at a reduced rate, muttering something about having dealt with HOA nonsense on 3 other jobs that year alone. "Half these boards think they own land they've never set foot on," he said, hauling another stone block into place like the lawsuit was simply whether to work around. Linda, meanwhile, used the lawsuit filing as an opportunity to hold what she called a community town hall, ostensibly to discuss access and safety concerns, but which quickly became a platform for painting me as an obstructive, litigious neighbor threatening the collective good of Meadowbrook Ridge over what she framed as simple community cooperation. I attended the town hall with Carla at my side, mostly to watch and take notes rather than argue, since Carla had warned me that anything I said publicly could be twisted and used later in the actual court proceedings. Watching Linda work the room, calm and practiced, I understood for the first time just how good she'd become at this. She spoke about safety concerns regarding our horses near the gravel road, implying, without quite stating outright, that livestock wandering unsupervised posed a danger to children walking to the bus stop, despite the fact that our fencing had never once failed in over a decade, and no horse had ever escaped onto that road. A week later, someone called Animal Control anonymously, reporting neglected and dangerous livestock on our property. The inspector who came out found nothing wrong. Our horses well-fed, well-groomed, properly fenced, and left almost apologetic, admitting the complaint had described conditions that didn't match anything he found once he actually walked the pasture. Emma, who loved our horses more than almost anything else in her 10-year-old world, cried when she overheard Rachel and me discussing the animal control visit, terrified that someone might try to take her favorite pony away over a lie. I told her the horses were safe, that nobody was taking anything from us, though privately I wasn't nearly as certain as I sounded. Tyler, furious in a way that worried me more than his usual teenage frustration, wanted to confront Linda directly, convinced beyond doubt that she'd called animal control herself. I told him to stay away from her entirely, that anything he said or did could hand her exactly the kind of incident she needed to justify everything she'd been claiming about our family. Rachel started documenting Emma's distress too, not out of calculation but because Carla had, gently, suggested we keep track of how this campaign was affecting the kids, in case it ever mattered for the case. Felt strange, cataloging our own children's grief as evidence. But by then almost everything in our lives had become material for one file or another. Then came the accident. Parked at the very end of the gravel road near our new wall, was found one morning with a dented front bumper, Linda claiming she'd struck loose stone debris that had allegedly rolled from our construction site into the roadway, injuring her wrist when she braked suddenly to avoid worse damage. Chad Pearson filed a personal injury claim within days, citing hazardous debris from an unsecured construction zone, seeking damages for medical expenses and pain and suffering on top of the existing lawsuit over the wall itself. Sam, incredulous, insisted no stone from his careful, staged work had ever come anywhere near rolling loose onto the road. Our new trail camera, still mounted near the gate out of habit, had captured a partial angle of that section of road the night before the supposed accident. And though the footage was grainy, it clearly showed no debris scattered across the gravel, nothing but Linda's own Escalade idling there for several minutes before driving away. Carla forwarded the footage to our insurance company immediately, and their adjuster, reviewing it alongside Linda's claim, flagged inconsistencies that prompted a formal fraud investigation into the injury claim itself, an investigation that would take weeks to resolve but that instantly changed the tone of every conversation Carla and I had going forward. Around this same time, Harold finally told Rachel something he'd apparently been sitting on for months, too frightened to say out loud until now, that Linda had confronted him privately after one meeting, mentioning, almost casually, that she knew about a decades-old DUI charge he'd quietly kept off his public record, one that could cost him his state contracting license if it surfaced. Harold hadn't done anything since that conversation except go quiet on the board, voting however Linda wanted, terrified that crossing her would mean his old mistake ending up in front of the licensing board that controlled his livelihood. He apologized to Rachel for his silence, admitting he'd been too afraid to help us sooner. Diane, once Harold finally spoke up, admitted she'd suspected something similar was happening to at least one other board member, a woman named Priya who'd resigned suddenly 6 months earlier without explanation, right around the time Linda had started expanding her control over the board's legal spending decisions without much resistance from anyone. I asked Carla whether any of this, the blackmail, the animal control lie, the staged accident, actually helped our case, or whether it was simply ugly noise surrounding the real legal fight over the easement and the wall. Carla's answer surprised me. "All of it helps," she said. "Pattern matters." That week, construction on the wall was disrupted again. This time more seriously. Someone backed a pickup truck into a freshly poured section overnight, cracking 3 days of Sam's work clean through before speeding off. Our trail camera caught only a blur of taillights, too dark and too fast to identify the vehicle clearly. Sam swore under his breath more that morning than I'd heard from him in weeks of working together, surveying the cracked concrete with genuine anger. "Somebody really doesn't want this wall finished," he said, already calculating how many extra days of work the damage would cost us, on top of everything else piling up that month. I reported the incident to the sheriff's department again, and this time, thankfully, it wasn't Deputy Roy who responded but a detective named Ferris, someone from outside the immediate patrol rotation who seemed genuinely unaware of, and unbothered by, whatever quiet local politics had kept our earlier complaints from going anywhere. Detective Ferris asked pointed questions about the ongoing HOA dispute, taking careful notes when I mentioned the lawsuit, the animal control complaint, the staged accident claim, and the earlier fence sabotage caught on our first camera. "That's a lot of coincidences pointing one direction," he said, closing his notebook. "I'd like to look at all your footage together." Carla, meeting with Ferris separately, formally requested Deputy Roy Kowalski be removed from any future involvement in our case, citing his family relationship to Linda as an obvious conflict of interest that should have disqualified him from the very first report over a year earlier. The sheriff's department quietly agreed, reassigning our case file without much public comment. With Ferris now consolidating everything, the vandalism, the fraud investigation, the animal control lie, the pattern Carla had promised would eventually matter started forming into something undeniable on paper, even if none of it yet proved who exactly had backed a truck into our wall in the middle of the night. Rachel, going through Tyler's trail camera footage frame by frame one evening, paused on a blurry figure from the fence-cutting incident weeks earlier, something about the build and the slouched walk nagging at her. She pulled up an old community Facebook photo from a barbecue the summer before, and the resemblance stopped her cold. The young man in the hoodie looked remarkably like Brody, Linda's 20-year-old nephew, who'd moved into her guest house the previous spring after some vague trouble back in his home state that nobody in the neighborhood ever discussed in detail. Rachel showed me the photos side by side, and neither of us could shake the resemblance. I brought the comparison to Detective Ferris rather than confronting anyone directly, and he agreed the resemblance warranted a closer look, though he cautioned that a grainy nighttime clip and a Facebook photo weren't enough on their own to build a case. "Keep the camera running," he told me. "If it's him, he'll show up again." In the meantime, Chad Pearson's personal injury claim on Linda's behalf hit a wall of its own. The insurance investigation concluded there was no evidence of debris on the roadway matching her account, and flagged the claim as likely fraudulent, a finding that would eventually matter far more than any of us realized in the moment. Linda didn't back down publicly even as that claim crumbled quietly behind the scenes. If anything, she leaned harder into the community narrative, posting an update to the HOA Facebook page about ongoing safety hazards near our property, carefully worded enough to avoid outright lying while still implying our family remained the source of every problem in the neighborhood. The next HOA meeting turned openly hostile for the first time. several residents, some who'd stayed quiet for over a year, finally standing up to ask pointed questions. About legal spending, about Harold's sudden silence, about why animal control had been called on a farm that had operated safely for over a decade without incident. Linda handled the pushback with practiced calm, deflecting each question with vague reassurances about ongoing legal processes and protecting community interests. But I noticed, watching closely, that her hands stayed clasped tightly on the table the entire meeting, knuckles pale, a small tell that hadn't been there in earlier, easier confrontations. Diane, emboldened by the room's shifting mood, finally moved to formally request an independent audit of HOA legal expenditures over the past 18 months. A motion that, for the first time since Linda took the presidency, actually received enough seconds and votes to pass despite Linda's visible efforts to table it once again. The audit wouldn't produce results for weeks, but its mere approval felt like the first real crack in Linda's control over the board, and I left that meeting feeling something shift in the room's collective mood. Not quite sympathy for our family yet, but something close to doubt about the woman who'd run things unquestioned for so long. That same week, our trail camera finally caught a clearer shot, this time in better light near dusk, of a young man matching Brody's build cutting across the pasture edge toward the half-repaired wall, carrying what looked like a crowbar. Detective Ferris reviewed the footage and agreed it was strong enough to bring Brody in for questioning. Brody, questioned separately by Ferris, folded quickly under pressure, admitting he'd cut the fence months earlier and cracked the wall with his aunt's spare truck, though he insisted, almost pleadingly, that Linda had never explicitly told him to do it, only that she'd mentioned how much easier things would be if the wall never got finished. That distinction, never explicitly told, only mentioned how much easier things would be, became, according to Carla, exactly the kind of language prosecutors and civil attorneys alike look for. The careful, plausible deniability of someone experienced enough to suggest without ever quite instructing, leaving her nephew to absorb whatever consequences followed. Brody faced vandalism charges of his own, separate from anything connecting directly back to Linda, and though he initially seemed willing to cooperate fully against his aunt, a visit from Chad Pearson the following day left him suddenly reluctant to say anything further, citing family loyalty in a statement that felt rehearsed rather than heartfelt. Carla wasn't surprised by Brody's sudden silence. Family protects family, especially when there's money and a house involved, she said, reminding me that Brody was living rent-free in Linda's guest house, dependent on her goodwill in a way that made testifying against her a genuinely frightening prospect regardless of what he'd already admitted. Still, Ferris had enough. Brody's initial statement, the trail camera footage, the timeline connecting the vandalism to the exact weeks Linda's lawsuit and legal pressure had escalated to build a case file that, combined with the fraudulent injury claim and Diane's approved audit, painted a picture too consistent to dismiss as coincidence any longer. Word of Brody's arrest spread through the neighborhood faster than any HOA newsletter ever could, and for the first time, public opinion in Meadowbrook Ridge began visibly tilting away from Linda. Neighbors who'd stayed carefully neutral for over a year suddenly willing to admit, quietly, that something about her leadership had never quite added up. Linda, cornered by the shifting mood, doubled down instead of retreating, telling anyone who'd listen that Brody had acted alone out of some misguided idea of loyalty, and that she herself had no knowledge whatsoever of his actions. a claim that grew harder to believe with every new detail Detective Ferris uncovered that month. The independent audit Diane had pushed through finally returned preliminary findings, revealing tens of thousands of dollars in HOA legal fees routed to Pearson and Associates over 18 months, far beyond what any ordinary easement dispute should have cost. Alongside unexplained consulting fees paid to an LLC that auditors couldn't immediately trace back to an owner. Carla, reviewing the audit alongside her own property records research, recognized the LLC name instantly, the same shell company Linda had used to quietly purchase 2 homes near the proposed second subdivision entrance years earlier. The discovery that had first revealed her financial motive for wanting our gravel road turned into a paved thoroughfare. What had started as a fight over 4 minutes of commute time now looked, on paper, like a woman using HOA funds and her own board authority to pay her son-in-law's law firm for a lawsuit designed to seize land she needed for a real estate play she'd quietly set up years before anyone suspected her motives. I brought this connected picture to Detective Ferris myself, laying out the LLC purchases, the stalled subdivision application, the legal fees, and the vandalism timeline side by side. He whistled low, flipping through the pages. "This isn't a neighbor dispute anymore," he said. "This looks like fraud, and maybe embezzlement, depending on how those funds were approved." Linda, perhaps sensing the walls closing in faster than her lawyer could manage, requested an emergency HOA meeting of her own, framing it as an opportunity to clear the air about recent rumors before the audit's full findings became public. A meeting that would become, in hindsight, one of the most consequential of the entire dispute. I debated whether to attend, unsure if showing up would help or simply give Linda another stage to perform on. But Carla insisted, reminding me that judges and juries alike tend to notice who shows up to face scrutiny directly and who hides behind lawyers and prepared statements instead of answering questions in the room. The meeting was packed. More residents attending than I'd ever seen at a single HOA gathering. Word having spread about Brody's arrest and the vague, unsettling audit findings circulating through group chats and driveway conversations all week. Linda arrived composed as ever, though her usual entourage of loyal supporters looked noticeably thinner than before. She opened by addressing Brody's arrest directly, calling it a painful family matter she deeply regretted, before pivoting quickly to insist the audit findings were still preliminary and easily explained once the full context came to light, a line that landed with visibly less confidence than her usual practiced reassurances. Diane, standing at the back of the room, asked the question everyone had clearly been waiting for someone to voice out loud: whether Linda could explain the LLC connected to both the unexplained consulting fees and the property purchases near the proposed second entrance. The room went quiet in a way I hadn't heard in over a year of these meetings. Linda's composure cracked, just slightly, a pause lasting a beat too long before she answered that the LLC was a private family investment unrelated to HOA business. A claim that satisfied absolutely no one in a room now armed with an audit report suggesting otherwise. Page by uncomfortable page. Harold, finally free of whatever silent fear had gripped him for months, stood and read aloud the specific line items from the audit connecting HOA legal fund disbursements directly to Pearson and Associates invoices dated the same weeks as key filings in the lawsuit against our family. Numbers that added up to far more than any easement case justified. By the time Harold finished reading, half the room was murmuring, several residents already pulling out phones to photograph the audit pages projected on the meeting room screen, and Linda, for the first time since taking the HOA presidency, looked less like a woman in control of the room and more like one running out of road. Rather than resign, or even slow down, Linda spent the days following that meeting working the phones, calling loyal residents one by one, reframing the audit as a witch hunt orchestrated by disgruntled board members with personal grudges against her leadership. It was, I had to admit, a masterclass in refusing to accept reality. She called an emergency session of her own the following week, not to address the audit findings directly, but to introduce a surprise motion attempting to remove both Diane and Harold from the board entirely, citing vague accusations of conduct unbecoming that conveniently avoided any mention of the financial questions still hanging over her own leadership. The motion failed, narrowly, thanks largely to residents who'd shown up specifically to prevent exactly this kind of maneuver. But the attempt itself told me everything I needed to know about how far Linda was willing to go rather than face the consequences quietly building against her from every direction at once. Around this time, Rachel found a note tucked under our windshield wiper one morning, and signed but unmistakable in tone, warning that some walls come down eventually, one way or another, vague enough to deny writing if confronted, specific enough that neither of us doubted for a moment who'd left it there overnight. I brought the note straight to Detective Ferris, who added it to the growing case file without much surprise, noting that escalating threats often followed. Exactly this pattern once someone facing serious consequences ran out of legal or social options and started reaching for something closer to intimidation instead. Carla, reviewing the note alongside everything else, grew visibly more concerned than I'd seen her at any point in the case so far. "This isn't paperwork anymore," she said. "I want cameras on every side of your property, not just the gate. And I want your family thinking seriously about their evening routines for a while." Rachel didn't sleep well after that note, checking on Emma and Tyler more often than usual, jumping at headlights passing on the road outside our window. I hated watching my wife move through her own home like a guest bracing for something. Hated more that I couldn't promise her, honestly, that the threat wasn't real. Tyler, meanwhile, grew quietly determined rather than frightened, expanding his camera network across the property himself, researching cheap wireless options late at night, treating the whole unnerving situation like a problem he could out-engineer if he just built enough coverage to catch whatever came next before it caused real harm. 2 additional cameras went up within days. One covering the horse pasture gate on the far side of the property. One aimed down the long driveway toward the road, both feeding footage to an app on Tyler's phone that pinged whenever motion triggered the sensors. Day or night, regardless of where any of us happened to be standing. For nearly a week, the new cameras caught nothing but ordinary nighttime wildlife, and I let myself hope, again, that the note had been an empty gesture, a last desperate flex from a woman who understood, deep down, that she'd already lost far more ground than she was willing to admit out loud to anyone. I was wrong. On a Thursday, Tyler's phone buzzed with a motion alert from the pasture camera, and when he pulled up the feed, his voice cracked calling for me from down the hall. Someone was at the pasture gate, working the latch open in the pale glow of the motion light. I ran outside in bare feet, flashlight in hand, reaching the pasture just as the gate swung wide and our 3 horses, startled and confused, began drifting toward the open gap and the gravel road beyond it, the same road Linda had fought so hard, for so long, to claim as hers. I managed to turn 2 of the horses back toward the pasture with nothing more than shouting and waving arms. But our oldest gelding, Duke, skittish since a storm years earlier, bolted straight through the open gate and onto the road just as a pair of headlights swung around the bend toward him at speed. The car braked hard, tires shrieking against gravel and asphalt, missing Duke by what felt, in that frozen half-second, like inches rather than feet. The driver, a young man on his way home from a late shift, sat shaking behind the wheel afterward, telling me he genuinely believed he was about to hit and possibly kill a horse in the dark. I spent the next 20 minutes coaxing Duke back through the gate with Tyler's help, hands trembling long after the adrenaline should have faded, while Rachel called the sheriff's department, this time asking specifically for Detective Ferris by name, unwilling to risk another indifferent response from anyone unfamiliar with everything already on file. Ferris arrived within the hour, walking the pasture fence line with a flashlight of his own, examining the gate latch closely before turning to the footage Tyler had already pulled up on his phone, footage that showed, unmistakably this time, not Brody's build or his hooded silhouette, but Linda herself, working the latch open with her own hands. The footage was dark, grainy at the edges, but the angle caught enough of her face beneath the motion light for Ferris to confirm what none of us had quite dared say out loud yet. Linda Kowalski, HOA president, had personally opened a livestock gate onto a public road at midnight, endangering a driver and a horse to make some point only she fully understood. Rachel sat on the porch steps afterward, staring at nothing, saying quietly that she'd expected fines, lawsuits, even vandalism from someone as determined as Linda had proven herself to be, but this, an animal loose on a dark road in front of an oncoming car, felt like a line she hadn't believed anyone would actually cross. Ferris took the footage that night, informing us he'd be seeking a warrant for reckless endangerment charges against Linda directly, separate from anything still pending regarding the fraudulent injury claim or the HOA financial audit, describing it as the clearest, most serious incident in the entire case file he'd assembled over the preceding weeks. Carla, notified first thing the next morning, moved immediately to request an emergency restraining order against Linda on our family's behalf, arguing that a woman who'd already demonstrated willingness to endanger a stranger's life over a property dispute posed an ongoing, credible risk to our safety that the court could no longer reasonably ignore. The restraining order hearing was scheduled within days, unusually fast given the circumstances, and Chad Pearson, representing Linda, seemed visibly rattled for the first time throughout the entire case, requesting a continuance that the judge denied outright once Ferris's report and the pasture footage were formally entered into the record. Linda, for her part, didn't attend that first hearing personally, sending Chad instead to argue, unconvincingly, that the footage was ambiguous and could show any number of people near the gate that night, an argument that collapsed almost immediately once the judge reviewed the timestamped, clearly lit footage Ferris had already enhanced for clarity. The restraining order was granted, barring Linda from coming within a set distance of our property, our family members, and effectively the entire gravel road dispute that had consumed our lives for well over a year. A small but genuinely significant victory that felt, for the first time, like the tide fully turning against her. Word of the restraining order spread through Meadowbrook Ridge faster than any HOA announcement ever had. And this time there was no ambiguity left for anyone to hide behind. A woman who'd endangered a stranger's life and nearly killed a horse over a property dispute wasn't a controversial neighbor anymore. She was, plainly, a danger. The HOA board, without Linda present to steer the meeting, voted unanimously to suspend her presidency pending the outcome of the criminal investigation, installing Diane as interim president in a session that lasted less than 20 minutes. A stunning contrast to the hours-long, carefully managed meetings Linda had run for the past 2 years. Even as the criminal case against her deepened, Carla continued pressing forward on the civil lawsuit and the easement claim itself, determined not to let Linda's reckless behavior overshadow the underlying legal fraud that had started this entire nightmare, the fabricated document she'd relied on from the very beginning to justify taking our land. Carla hired a forensic document examiner, a meticulous woman named Dr. Reyes, to analyze the typed and signed page Chad had produced during mediation as proof of the supposed agreement between the original developer and my father. The page Linda had insisted for over a year represented a legitimate, decades-old understanding about the gravel road.
Dr. This took less than a week to produce a damning conclusion. The paper stock used for the document matched a brand manufactured no earlier than 5 years prior, decades after the supposed agreement, and the typeface used matched a font that hadn't existed in any commercial printer during the era the document claimed to originate from.
In other words, the entire private agreement Linda had waved around for over a year, the foundational claim behind the prescriptive easement lawsuit and every violation, notice that followed, was a modern forgery, created sometime in the past several years and dressed up to look like an old, forgotten handshake deal from decades earlier. Carla filed Dr. immediately, formally accusing Linda of fabricating evidence in a civil proceeding, a charge serious enough on its own to potentially end any remaining credibility her legal team had left, layered now on top of reckless endangerment charges and a fraud investigation into her staged injury claim from months earlier. Chad Pearson withdrew from representing Linda entirely within days of the forgery findings becoming public, citing, in a brief statement, irreconcilable differences regarding case strategy, language that fooled absolutely nobody who'd been paying attention to how thoroughly his mother-in-law's legal foundation had just collapsed underneath both of them at once. Without a lawyer, without her HOA presidency, and now facing multiple criminal and civil proceedings simultaneously, Linda still refused to concede anything publicly,
posting a lengthy statement to her personal social media, insisting the forgery findings were manufactured by
Diane, now serving as interim HOA president, called a full community meeting to formally address everything that had come to light, the forged document, the reckless endangerment charge, the fraudulent injury claim, the questionable LLC purchases, determined to give residents a complete, honest accounting after years of half-truths from the previous administration. I attended that meeting with Rachel and Carla, unsure what to expect after everything that had already happened, watching as Diane methodically walked the packed room through 18 months of documented deception with a calm, careful thoroughness that felt almost like an apology on behalf of the entire board for how long it had taken to see clearly. Several longtime residents stood up during that meeting to formally apologize, some to us directly, admitting they'd repeated rumors or signed onto HOA positions without ever questioning Linda's claims closely enough. A wave of quiet accountability that, while it didn't erase the past year and a half, genuinely surprised me in its sincerity. Harold, visibly relieved to finally be free of whatever leverage Linda had held over his old DUI record, spoke publicly for the first time about the blackmail, explaining to the room why he'd stayed silent for so long and offering his own apology for the votes he'd cast out of fear rather than genuine conviction. Priya, the board member who'd resigned mysteriously months earlier, returned to that meeting as well, confirming what Diane had long suspected, that Linda had pressured her out of her position using threats related to a private family matter. Details she still wasn't ready to share publicly but confirmed clearly enough for the room to understand the pattern. By the end of that meeting, the community voted overwhelmingly to formally remove Linda from any HOA position permanently, regardless of the ongoing criminal proceedings, and to pursue recovery of the misappropriated legal fees through whatever civil means the board's new council recommended once everything worked its way through the courts. Linda, informed of the vote through Diane rather than attending herself, responded with a statement threatening to sue the entire HOA board for defamation, a threat that Carla, when she heard about it, actually laughed out loud at for the first time in the entire 18-month ordeal we'd been living through together. She has no lawyer, no case, and a forensic report proving she forged evidence, Carla said, still shaking her head. At this point, threatening to sue everyone isn't strategy. It's just what's left once every actual option has run out. I believed her, though some old, tired part of me still braced for whatever came next. What came next? A week later, was Linda showing up uninvited at our property line despite the restraining order still technically in effect, standing on the far side of the finished stone wall, staring at it silently for several long minutes before Tyler's camera caught her turning and walking slowly back toward her car without a word. I called Detective Ferris immediately, and though Linda hadn't technically crossed onto our land or approached within the exact distance specified in the order, her presence anywhere near the property triggered an immediate review by the court, resulting in tighter restrictions and a formal warning that any further violation would mean immediate arrest. Rachel, watching that footage of Linda staring silently at the wall, said something that stuck with me for a long time afterward, that whatever this had ever been about, easements or shortcuts or land value, it had stopped being any of those things a long time ago and become, simply, about a woman who couldn't stand losing. The criminal case for reckless endangerment moved forward that same month, prosecutors adding charges related to the forged document and, after the insurance investigation concluded formally, fraud connected to the staged injury claim, stacking 3 separate cases against a woman who, less than 2 years earlier, had run unopposed for HOA president in a room full of silent mourners. I finished the last section of the stone wall myself that week, working alongside Sam in the late afternoon light, setting the final capstone in place while Emma and Tyler watched from the porch. And for the first time since this entire nightmare began, I let myself believe we were finally approaching the end of it. With 3 separate legal fronts now moving forward, the criminal reckless endangerment charge, the fraud investigation into the staged injury claim, and our own civil case over the forged easement document. Carla began preparing me for what she expected would be a consolidated hearing where much of this would finally come together in one room. Brody, still facing his own vandalism charges, agreed through his public defender to testify fully against Linda in exchange for a reduced sentence. No longer protected by Chad Pearson's earlier visit, now that the entire family's legal shield had collapsed around them along with every other piece of Linda's carefully constructed authority. His formal deposition detailed exactly how Linda had described the wall and the fence as obstacles standing between the family and what's rightfully going to happen to
that road eventually. Language Carla underlined twice in her notes as further proof of premeditated intent stretching back further than any of us had initially realized.
Priya, finally ready to speak plainly about why she'd resigned from the board, gave her own statement describing how Linda had threatened to expose a private health matter involving her mother unless Priya voted consistently with Linda's legal spending requests, confirming a pattern of coercion that extended well beyond just Harold's old DUI record. Carla compiled all of it: Brody's deposition, Priya's statement, Dr. Reyes's forensic analysis, Ferris's reckless endangerment case file, and the insurance fraud investigation into a single, devastating civil complaint seeking not just removal of the fraudulent easement claim, but damages for the sustained campaign of harassment our family had endured for well over 18 months. I read through the full complaint one evening at the kitchen table, struck by how strange it felt seeing the entire ordeal laid out in cold, sequential legal language, dates, exhibits, sworn statements, reducing everything that had terrorized my family for a year and a half into a document that finally, undeniably, told the truth. Rachel sat beside me reading the same pages, quiet for a long time before saying that she almost felt sorry for Linda, buried now under the weight of her own choices. Though the feeling passed quickly once she remembered Duke bolting into the path of that oncoming car in the dark. Linda, isolated and unrepresented for weeks after Chad's withdrawal, eventually hired a new attorney from out of state, a man named Preston who specialized, according to Carla's quick research, in exactly this kind of last-ditch defense work for clients running out of both money and public sympathy. Preston's opening strategy, once he filed his appearance, leaned heavily on a claim that surprised even Carla, that Linda had been experiencing early signs of cognitive decline over the past year, subtly implying that her more erratic decisions, including the pasture gate incident, resulted from confusion rather than deliberate intent. I didn't know what to make of that claim at first, uncertain whether it was a genuine medical concern or simply the last available strategy for a woman who'd exhausted every other option. And Carla, though skeptical, cautioned me that courts took such claims seriously enough that we'd need real counter-evidence, not just doubt. Diane, informed of the cognitive decline claim, seemed genuinely startled, admitting she'd never noticed anything resembling confusion or memory trouble in Linda's sharp, calculated handling of board meetings, financial spreadsheets, and legal correspondence right up until the moment everything started collapsing around her a few weeks earlier. Carla requested Linda's own text messages and emails from the weeks surrounding the PastureGate incident be entered as evidence, reasoning that genuine cognitive confusion would likely show itself in disorganized, inconsistent communication rather than the clear, deliberate planning we suspected the messages would actually reveal once subpoenaed properly. Those messages, once obtained through the court, told a very different story than Preston's defense wanted the room to believe. Detailed notes to herself about camera blind spots around our property, timestamps referencing when our family typically went to sleep, and a message to Brody sent hours before the gate incident reading simply, "Tonight. No cameras on that side." Reading that message for the first time, sitting across from Carla in her office, I felt something shift in my chest that wasn't quite relief and wasn't quite anger, but some third thing entirely, the cold, clarifying certainty that everything Linda had ever claimed about confusion, misunderstanding, or good intentions had been a performance from the very beginning. Word of the no cameras on that side message reached the neighborhood almost as fast as the earlier rumors about our own family once had, though this time the community's reaction ran in exactly the opposite direction. Sympathy and support pouring toward us in a wave that felt, after 18 months of isolation, almost disorienting. Our farm stand saw its busiest week in years. Longtime customers returning alongside curious newcomers who'd only heard about the situation through the grapevine. Several of them apologizing unprompted for ever doubting us. Buying eggs and tomatoes as though restocking a pantry could somehow also restock the trust we'd lost. Emma's friends came back too. Invitations flowing freely now. Her 10th birthday party that spring drawing nearly the whole class after months of quiet exclusion. And watching her laugh in the backyard with kids who'd avoided her for half a year. I felt something loosen in my chest that had been tight for a very long time. Tyler, meanwhile, found himself something of a minor local celebrity among the neighborhood teenagers. His scrappy trail camera setup credited, accurately, with catching nearly every piece of decisive evidence in the entire case. A fact he tried to downplay with teenage nonchalance while clearly, privately, glowing with quiet pride whenever someone brought it up. Sam finished the last remaining section of the wall's capstone that same week, and though I'd built it originally out of fear and frustration, standing back to look at, the finished stonework now felt different, less like a barrier built in a panic, more like a boundary the whole community had finally come to understand and respect. Diane, still serving as interim president, pushed through a formal HOA resolution reimbursing our family for the legal fees connected directly to defending against the fraudulent easement claim, a motion that passed with almost no debate, a stark contrast to the fights over far smaller matters just months earlier. Harold, still working through the fallout of admitting his own silence under blackmail, quietly reached out to offer free electrical work on our barn as a gesture of apology. An offer I accepted more for the sake of letting him make peace with himself than for any real need I had for the help. Priya, going through old board archives while helping Diane prepare records for the upcoming hearing, found something none of us had expected, a folder of Frank Kowalski's own handwritten treasurer notes from years earlier, preserved almost accidentally in a box nobody had bothered clearing out since his death. In those notes, dated years before Linda ever took the HOA presidency, Frank had written plainly that the gravel road access was informal, revocable at owner's discretion, explicitly acknowledging my father's ownership and permission-based arrangement rather than any claim to a formal, permanent community easement. Frank, turned out, had understood the truth of the situation all along, recording it honestly in his own handwriting years before his widow ever tried to rewrite that history into something entirely different, a discovery that quietly demolished any remaining possibility that Linda's claims stemmed from genuine, honest confusion about old agreements. Carla entered Frank's notes into evidence immediately, calling them the single most damning document in the entire case, precisely because they came not from us, not from a hired expert, but from Linda's own late husband, the very person she'd once claimed originally granted the easement she'd spent 2 years trying to steal. I thought about Frank sometimes in the days that followed. A man I'd barely known beyond distant nods across the mailbox kiosk, wondering whether he'd ever imagined his careful, honest treasurer's notes would someday become the evidence that finally exposed his own wife's elaborate fraud years after he was gone. Rachel, reading through copies of Frank's notes at our kitchen table, said quietly that it almost felt like he'd left something behind for us without ever knowing it. A small, unintended kindness buried in old paperwork. The truth simply waiting patiently in a forgotten box for someone to finally need it. The upcoming consolidated hearing, now scheduled for the following month, would bring together the reckless endangerment charge, the fraud investigation, the forgery accusation, and our civil claim for damages all under one judge's review. A single day that Carla warned me would likely determine the outcome of nearly everything we'd endured. The night before the hearing, Rachel and I sat on the porch long after the kids had gone to bed, looking out at the finished stone wall glowing pale under the moonlight. Neither of us saying much, both of us aware that tomorrow would either close this chapter for good or drag it out even longer. Tyler came out to join us eventually, unable to sleep either, admitting quietly that he still checked his phone every few minutes out of habit. Even though Ferris had assured us Linda's continued violation of the restraining order made any further contact from her extraordinarily unlikely before the hearing concluded. Emma slept through the night undisturbed for what felt like the first time in months, and Rachel checked on her twice anyway, standing in the doorway watching our youngest breathe steadily in the dark, carrying a fierce, protective relief that had been rare enough lately to feel almost unfamiliar. Carla called late that evening with one final update. Preston, Linda's new attorney, had quietly requested a plea negotiation on the reckless endangerment charge that afternoon. A request Carla took as confirmation that even Linda's own legal team now understood how thoroughly the evidence had turned against her. I barely slept, running through 18 months of gates and fines and forged documents and midnight phone calls, and when morning finally came, gray and cool, I dressed for court feeling less like a man walking into a hearing and more like someone finally closing a very long, very heavy door. The consolidated hearing convened in a courtroom larger than any space I'd been in over the past 18 months of folding chairs and fluorescent-lit meeting rooms.
And for the first time since this entire ordeal began, Linda Kowalski sat directly across from us rather than behind a folding table smiling her practice smile.
She looked smaller somehow, stripped of the HOA presidency, the loyal board majority, and the easy confidence that had carried her through 2 years of meetings where nobody dared question her too closely, though her posture remained rigid, chin lifted, refusing to appear anything less than composed in front of a courtroom full of neighbors. The judge, a measured, unhurried woman named Judge Okafor, opened by outlining the scope of the day's proceedings, the reckless endangerment charge, the fraudulent injury claim, the forged document accusation, and our civil complaint for damages, noting dryly that she'd rarely seen a single property dispute generate quite this much paperwork. Carla presented first, walking the court methodically through 18 months of documented harassment, beginning with the original 1974 plat map showing clean, unbroken ownership along our northern boundary, then moving deliberately through every fabricated violation notice, every rumor, every fine designed to bleed us financially into surrendering our own land. She introduced Dr. whose forensic testimony on the forged easement document landed with visible weight across the courtroom, explaining in clear, precise terms how the paper stock and typeface both postdated the document's claimed origin by decades, leaving no reasonable explanation beyond deliberate, recent fabrication. Detective Ferris testified after that, laying out the reckless endangerment case methodically, the pasture gate footage, Linda's face clearly visible beneath the motion light, the near miss with the oncoming driver, and the chilling text message instructing Brody to ensure no cameras on that side hours before the incident occurred. Brody, testifying under his plea agreement, described in halting, uncomfortable detail how Linda had directed him toward the fence cutting and the wall sabotage without ever issuing explicit orders, always phrasing things as suggestions and observations rather than commands, a pattern he now understood, painfully, as deliberate insulation for herself. Priya's testimony followed, describing the blackmail over her mother's private health matter in a steady, quiet voice that carried further across the courtroom than any raised voice could have, and I watched several jurors, and even a few residents seated in the gallery, shift uncomfortably as she spoke. Harold testified next, visibly nervous but resolute, admitting publicly for the first time the details of the DUI blackmail that had kept him silently voting against his own conscience for months, his voice cracking slightly when he described the relief of finally saying it plainly, under oath, in a room that couldn't be intimidated into silence. Carla closed her portion of the presentation with the LLC records, tracing the property purchases near the proposed second subdivision entrance directly back to Linda's maiden name, alongside the audit findings showing tens of thousands of dollars in HOA funds routed to Pearson and Associates for a lawsuit built entirely on a fabricated document. When it came time for Preston to mount Linda's defense, he opened by leaning heavily into the cognitive decline argument, describing his client as a grieving widow, overwhelmed by sudden responsibility, suggesting her more erratic actions over the past year stemmed from confusion rather than any deliberate scheme against her neighbors. Carla's cross-examination dismantled that framing within minutes, walking Linda's own subpoenaed text messages onto the record one at a time, detailed notes about camera blind spots, careful timestamps tracking our family's sleep schedule, and finally, the message to Brody instructing him to ensure no cameras covered the pasture gate that night. Does confusion plan around camera coverage, Mrs. Kowalski? And the question hung in the courtroom for a long, uncomfortable moment before Linda's composure finally, visibly cracked, her jaw tightening, her hands gripping the edge of the witness stand as though bracing against something she could no longer control. "You don't understand what it's like," Linda said suddenly, her voice rising, abandoning whatever careful script Preston had prepared her to follow. "I built this community. I protected it for years while Frank was alive and after he was gone. And none of you ever once thanked me for any of it." Judge Okafor asked her to answer only the questions posed. But Linda, something finally breaking loose after 2 years of careful control, kept talking anyway, insisting that the road, the land, all of it should have belonged to the community's future rather than one family sitting on acreage they don't even know how to use properly. "That land fed my family for 4 generations, I said quietly, though not from the stand, unable to stop the words from slipping out under my breath. And Judge Okafor's sharp glance silenced me instantly, though I noticed several jurors nodding slightly, as though the sentiment had landed anyway. Preston, visibly trying to regain control of his own witness, attempted to steer Linda back toward the cognitive decline narrative, asking gently whether she remembered sending the message to Brody at all, a question clearly designed to open the door for confusion or memory lapse rather than deliberate intent. Linda hesitated, and for a moment I thought she might actually claim not to remember, but something in her, pride, perhaps, or simple exhaustion after 2 years of maintaining a performance, made her answer honestly instead. "Of course I remember sending it," she said flatly.
I remember
That single admission, delivered without hesitation or evasion, effectively ended whatever defense Preston had hoped to build around confusion or diminished capacity, and I watched him lean back slightly in his chair, understanding, I think, that his client had just dismantled her own defense more thoroughly than any cross-examination could have managed. Judge Okafor called a brief recess after that exchange, and the courtroom emptied into the hallway in a low murmur of conversation. Rachel gripping my hand tightly, both of us too drained to say much of anything beyond quiet relief that the worst of the testimony seemed, finally, to be behind us. During that recess, Linda approached us in the hallway despite Preston's visible attempt to steer her away, stopping a few feet from where Rachel and I stood. Her composure fully returned now, cold and steady in a way that felt far more unsettling than her earlier outburst had. "You think this ends with you winning," she said quietly, low enough that only we could hear it. "That road was always going to be built eventually. You've just delayed the inevitable and cost yourself a great deal more than offense in the process." Then she turned and walked back into the courtroom without waiting for a response. I didn't answer her, mostly because I couldn't find words steady enough in that moment. But Rachel, beside me, said only, "She still thinks she's owed something," in a tone that carried more pity than anger, an observation that stayed with me for the rest of that long, exhausting day. When court resumed, Carla called Diane to testify about the community's broader experience under Linda's presidency, the pattern of intimidation and control extending well beyond our family alone, painting a fuller picture for Judge Okafor of exactly how thoroughly Linda had reshaped an entire neighborhood around her own personal ambitions. Diane described board members too frightened to vote their conscience, residents afraid to question spending, an entire community quietly reorganized around one woman's willingness to threaten and manipulate anyone who stood between her and whatever she decided she was entitled to, whether that was a road, presidency, or simple, unquestioned control. As Diane finished her testimony, something shifted visibly in Linda's expression. Watching the interim president she'd once dismissed so easily now describe, calmly and precisely, the full architecture of her manipulation laid bare for a judge, a jury, and a courtroom full of the very neighbors she'd spent years quietly controlling. Preston requested a short conference with his client following Diane's testimony, and when court resumed after the brief pause, his tone had shifted noticeably, no longer pressing hard on the cognitive decline defense, instead beginning to hint, carefully, at the possibility of a negotiated resolution rather than continuing through a full trial. Carla, sensing the shift, made clear during a sidebar with Judge Okafor that our family wasn't interested in a quiet settlement that let Linda avoid full accountability, insisting that whatever resolution emerged needed to include formal acknowledgement of the forged document, restitution for the legal costs, and full cooperation with the ongoing criminal proceedings. Judge Okafor, reviewing the mounting evidence already entered into the record, indicated she saw little reason to entertain a lighter resolution given the severity and duration of the conduct described, effectively closing off whatever soft landing Preston had hoped to negotiate for his client in those final hallway conversations. It was during the next brief recess, while attorneys conferred and the courtroom slowly refilled, that Linda made what would become the final, defining mistake of the entire 2-year ordeal. Rather than waiting quietly for court to resume, she walked out of the building entirely, got into her car, and drove. Rachel and I, stepping outside for air during the same recess, watched with a kind of disbelieving horror as Linda's Escalade pulled out of the courthouse lot and turned, unmistakably, in the direction of Meadowbrook Ridge, toward our farm, toward the wall, toward the one place she'd spent 2 years insisting she still had a claim to. I called Detective Ferris immediately, my hands shaking as I explained what we'd just watched, and he confirmed within minutes that Linda's abrupt departure during an active hearing, combined with her ongoing restraining order violation, gave deputies more than enough grounds to intercept her before she ever reached our property line. A patrol car caught up with Linda's Escalade less than 2 miles from our farm, lights flashing in her rearview mirror on the same stretch of road where, months earlier, Duke had nearly been struck by a startled driver in the dark. And this time, finally, she pulled over without incident, without argument, without anywhere left to go. She was taken into custody on the spot for violating the restraining order and for what the responding officer's report later described as an apparent attempt to approach the
protected property during active court proceedings, a charge that, combined with everything already stacked against her, effectively ended any remaining hope of a lenient outcome.
Word reached the courtroom before Linda herself was even fully processed at the station. Judge Okafor informed directly by Ferris's office, and I watched Preston's face when the news arrived, a look somewhere between exhaustion and quiet, resigned acceptance that his client had just made his job entirely impossible. When court reconvened without Linda present, Judge Okafor addressed the room directly, noting for the record that the defendant's abrupt departure and attempted approach toward the protected property during active proceedings would be considered alongside the existing charges when determining any remaining questions before the court that day. Carla used the remaining time to formally close our civil case, requesting the court declare the easement claim void based on Dr. Reyes's forensic findings, award damages covering our legal fees, lost farm stand income, and the emotional toll on our family, and permanently bar any future HOA claim to our northern property line. Judge Okafor took the matter under brief advisement before returning with a ruling that afternoon, declaring the alleged easement agreement fraudulent and unenforceable, awarding substantial damages to our family, and issuing a permanent injunction preventing the HOA, or any successor board, from ever again asserting a claim to our gravel road access. She further ordered Linda personally, rather than the HOA collectively, responsible for reimbursing the misappropriated legal fees traced through the audit, reasoning that the funds had been directed for Linda's personal benefit rather than any legitimate community purpose, a distinction that meant the rest of the neighborhood wouldn't bear the financial burden of her scheme. The reckless endangerment charge moved forward separately under criminal jurisdiction, and within a month, facing overwhelming evidence including her own text messages and sworn courtroom admission, Linda accepted a plea agreement rather than risk trial, resulting in a sentence that included jail time, probation, and a permanent restraining order extending well beyond the civil case's own terms. The fraudulent injury claim resulted in additional charges for insurance fraud, layered onto the sentencing, and prosecutors, reviewing the full pattern of forged documents, staged incidents, and financial manipulation, ultimately pursued embezzlement charges connected to the HOA legal fund disbursements that had flowed toward Pearson and Associates under false pretenses. Chad Pearson faced his own scrutiny from the State Bar Association once the forged document and misused legal fees came fully to light. His firm's role in the case drawing an ethics investigation that, according to Carla, would likely follow him for years regardless of how his marriage to Linda's daughter ultimately survived the fallout. Brody, cooperating fully throughout, received a lighter sentence for his vandalism charges, community service and probation rather than jail time, a resolution Rachel and I didn't fight, understanding by then that he'd been, in his own way, another person Linda had used and discarded once he'd served his purpose. The LLC properties near the proposed second subdivision entrance were ordered liquidated as part of the restitution package, the proceeds directed toward covering both our family's damages and the HOA's own legal costs, closing the financial loop on a scheme that had, from the very beginning, been about land value rather than convenience. News of the full ruling spread through Meadowbrook Ridge within hours, and by the following week, local news outlets picked up the story too, running segments on the fraudulent HOA president who'd forged documents, staged an accident, blackmailed board members, and endangered a stranger's life, all in pursuit of a real estate scheme years in the making. Diane, formally elected HOA president in the community vote that followed, worked with the board to overhaul the association's bylaws entirely, introducing transparency requirements for legal spending, term limits for board positions, and an independent oversight process designed specifically to prevent any single person from consolidating the kind of unchecked control Linda once held. Harold, cleared finally of whatever leverage had once controlled him, stayed on the board as treasurer under the new rules, working closely with Diane to rebuild trust in a position he'd once used, out of fear, to enable exactly the kind of abuse he now dedicated himself to preventing going forward. Priya returned to the board as well. Her earlier resignation formally acknowledged and apologized for by the community at large, and she and Diane became something like allies in the slow, deliberate work of restoring a sense of fairness to a neighborhood that had spent 2 years living under quiet, unacknowledged intimidation. Our farm stand, meanwhile, thrived in a way it never had before the entire ordeal began. Neighbors making a point of stopping by regularly, some out of genuine loyalty, some out of lingering guilt, most simply glad to have an ordinary, uncomplicated reason to see us that didn't involve HOA meetings or legal filings. Tyler's trail camera setup, once a scrappy homemade solution born out of frustration, became something of a local legend, and he eventually turned the hobby into a small side business helping other rural homeowners install their own affordable security systems, joking that Linda had accidentally launched his first real entrepreneurial venture. Emma's 10th birthday, celebrated fully surrounded by friends who'd once been kept away, became a marker in our family's memory of when things had genuinely turned a corner, the horses grazing peacefully in the pasture beyond the party, Duke among them, unbothered now by roads or gates or anything beyond the next mouthful of grass. Rachel went back to keeping the farm's books in relative peace for the first time in nearly 2 years. The color-coded folder of violation notices and legal correspondence finally retired to a filing cabinet rather than the kitchen table. A small, quiet symbol of a fight that had, at long last, actually ended. I walked the length of the finished stone wall most evenings that summer, running a hand along the cool stone Sam had laid with such steady patience through every disruption Linda had thrown at us, thinking sometimes about how strange it was that something built out of fear had ended up feeling, in the end, like peace. Linda served her sentence quietly, her Escalade sold, her HOA presidency a distant memory, her name mentioned around Meadowbrook Ridge now mostly in the past tense. A cautionary story parents told new residents about what happens when unchecked power gets handed to someone who mistakes control for leadership. Chad and Linda's daughter divorced within the year, and Chad relocated his practice out of state entirely, leaving Meadowbrook Ridge with one less familiar face and, according to Diane, one less complicated legal entanglement for the new board to worry about untangling from their own affairs going forward. The gravel road itself remained exactly what it had always been before any of this started, a quiet cut-through along our northern fence line, used occasionally, permissively, by the rare neighbor who asked first, exactly the way my father had always intended it, long before anyone thought to fight over it. Standing at the gate one evening that fall, watching Emma ride her pony along the fence line while Tyler adjusted one of his cameras nearby, I thought about how a woman's greed and pride had cost her everything she'd once had, while all we'd ever wanted, the whole time, was simply to be left alone on our own land. The following spring, the HOA board approved funding, unanimously this time, for a small historical marker near the gravel road, acknowledging its origins as a private agricultural access route rather than any community easement. Quiet, official correction to 2 years of documents that had once claimed otherwise. Carla closed our file formally that same spring, though she still checked in occasionally, more out of genuine friendship by then than professional obligation, joking once that our case had taught her more about forensic document analysis than a decade of ordinary property disputes ever had. Detective Ferris retired from active vandalism cases back to his usual detective work, though he stopped by the farm stand every few weeks anyway, buying eggs and asking after the horses, never quite losing interest in how the story he'd help unravel had actually ended for the family at its center. Diane's reforms held steady through her first full term as president. The HOA's finances transparent for the first time in years. Board meetings running shorter and quieter now that nobody felt the need to perform for an audience or fear retaliation for asking an honest question out loud. Harold eventually told Rachel, almost sheepishly, that he'd started attending every meeting sober and unafraid for the first time since Frank Kowalski's passing years earlier, grateful, in his own quiet way, for a community finally rebuilt around something closer to trust than fear. Brody, finishing his community service, sent a brief, awkward letter to our family that fall, apologizing plainly for the fence cutting and the wall damage, admitting he'd let fear of losing his aunt's support cloud better judgment he wished. Looking back, he'd trusted sooner. I never wrote back anything elaborate. Just a short note telling him I hoped he'd build something better with his life than what he'd been part of here. Because holding on to anger toward a 20-year-old who'd been used by someone twice his age felt, by then, like carrying weight I no longer needed. 2 years after Linda first drove through my gate like it belonged to her, I stood at the finished stone wall with Rachel beside me, watching the sun drop behind the tree line over land my family had worked for 4 generations. Finally quiet, finally ours. Without question, without argument. The wall never came down. Not once. Not through lawsuits or vandalism or a woman's desperate refusal to accept she'd lost. And somewhere along the way it had stopped being a barrier built out of fear and become something closer to a promise. That some things, once you fight hard enough to protect them, simply hold. Emma still rides her pony along that fence line most evenings. Tyler still tinkers with cameras nobody really needs anymore. And Rachel and I still sit on the porch some nights just watching the horses graze. Grateful, in the end, for nothing more complicated than an ordinary, undisturbed evening on our own land. Linda Kowalski never crossed that wall again. And neither did anyone else who mistook our family's patience for weakness. Because some gates, once you've fought hard enough to protect them, simply stay closed to the people who never had any right to open them in the first place. The end.